does not say you must make a closing argument, but it is a great idea to make a closing argument. In fact, one must agree with the, that remark there by our good friend Ian Molly, that perhaps, well, he doesn't say perhaps, that's my addition, that perhaps the closing argument is the reason why advocates exist. Of course, he is not saying that. He's not saying that to suggest at all that the other trial stages, are not important, or that the role of lawyers in those other stages, is not important. Of course it is. But he is saying that just to capture our imagination and to emphasize how important the closing is. And there was that other observation there, and you will share the citation of that case, that the closing argument can go a long, long way in redeeming a poorly tried case. If you make a good closing, that will go a long, long way. But nobody, of course, is suggesting at all that you do a very poor job during the previous stages, and then now you will just wait for the closing to impress people. No. I mean, it doesn't matter how eloquent you are, how good a public speaker you are. Even if you are Marcus Tullius Cicero, you cannot win your case merely through oratory, because the closing argument is about connecting the law and the evidence presented to show why your side should win. That's really what the closing argument is all about, right? But let's be very clear in our minds here. This language of closing argument, you may not see it in the statutes there, but you will see language like address the court generally, sum up the case. That's what the rules are saying. But they all mean really the same thing, a closing argument. Sometimes called closing speech, final speech, closing submissions, final submissions. There are so many variants of this thing. But we are very clear in our minds about, this is at the end of the hearing. Both sides have presented their evidence, or maybe the side responding has said, we don't wish to produce any evidence. So that is the close of the trial part. All right? So this word submissions, the word submissions is rather generic. Everything that counsel says from the bar, addressing the bench, is a submission. An opening statement is a submission. Even though we don't call it that, it is actually a submission. A skeleton argument is a submission. A closing argument is a submission. So the word submission is generic. Whatever counsel says to the bench, from the bar, not the witnesses, from the bar, is a submission. All right? So, opening statement, we know what that is. In the next few days, we're going to be talking about skeleton arguments. Skeleton arguments. These are written things that we file in court, in certain situations, ahead of some oral hearing, usually. And you can then go to court and do what we call highlighting, right? Skeleton arguments. For example, in interlocutory proceedings, when you have an application, the court may say, parties to file and exchange submissions. Come back on 30th of September to highlight that submission that the applicant makes. So your heading, when you look at the document, it will be called applicant's submissions. That is a skeleton argument. Respondent's submissions. That is a skeleton argument. Right? Also, in some civil suits that I think I've previously mentioned, where the court directs this case to be heard purely on the basis of affidavit evidence, without calling live witnesses to testify. Typically there, the court will also say, parties to file and exchange submissions. Constitutional petitions, judicial review proceedings, suits commenced by way of OS, presidential election petitions. Because of time shortage, we never do witnesses in court. We only use affidavit evidence. In those kinds of civil suits, parties will file submissions in advance. What are those? Skeleton arguments. Also, in appeals, both civil and criminal, the court may say parties to file submissions, written submissions, in support of their respective positions. What are those documents? Even though we don't call them that, skeleton arguments. Right? Then we have the closing argument, right at the end, where the presentation of evidence has been concluded by all the parties involved. Then that is when we have the closing. So, even though we call that document, when we file it, when we do it in writing, we call it plaintiff's submissions. That thing is plaintiff's closing argument. Right? If you make it orally, then we call it closing speech, or final speech, final submissions. Right? And so, we have, of course, looked at the relevant legislative statutory basis for the making of these arguments. You will notice that these are not provided for in the Evidence Act because they are not evidence. They are arguments. Now, you must distinguish between a statement and an argument. The opening is a statement. You are telling the court, this is what I intend to show, to prove, to demonstrate. You are making some promise. As we said earlier on, that the opening is essentially about what the evidence will show. And we actually say there that you don't argue when you are making an opening statement. An argumentative submission is objectionable. And in fact, the other side can object. Objection, Your Honor, argumentative. You don't say, Your Honor, the evidence we have is that there is bad blood between. No. hatujui. That is a conclusion. That's an argument. Bad blood, we can only see it once we see the evidence. Just say, I am going to prove there was a valid marriage under customary law. I'm also going to show that my client contributed to the acquisition of the property. That's it. No arguments at that point. But the closing is an argument. Many people mistakenly assume that the word argument is a negative word, that it has a negative connotation. No, it doesn't. In fact, an argument is a good thing. People need to argue more. The reason people fight is because they can't argue. To argue is a good thing. People must be encouraged to argue. Wives always tell their husband, you like arguing too much. But that's a good thing. Arguing is an extremely good thing. Because in an argument, all that I'm doing is attempting to show you my point of view of things and why you should agree with me and why I'm not on the wrong or whatever. So an argument is a good thing. In a closing argument, basically, because the court now has had the benefit of hearing the evidence and seeing it, whatever it is, what you are doing in the closing argument is persuading the court, saying to the court why a certain fact as presented in the hearing means that your side should win. That's the essence. Why a certain fact as presented in the evidence means that your side should win. That's what you are doing with a closing argument. All right? Now, your opening argument, not opening, closing argument should be, of course, supported by the evidence. It's essentially about the law and the evidence. The firm here has mentioned press, which is okay. There is no formula, really, for making a closing argument. One cannot prescribe and say, look, you must make it this way. This is what you must say. This is the formula. No. You can adopt whatever style you want. But one finds that, there are many ideas about this. IRAC is another useful idea of doing it. And I'm sure you've come across that mnemonic of that abbreviation. IRAC, issue, rule, application of analysis, then conclusion. What is the issue? What were the issues for determination in this case? Rule means the law. What does the law say on this point, on these issues? What has the evidence shown? That's the analysis part. Therefore, this means the conclusion. C is a conclusion. I is useful. Right? So you can see a typical trial process has the opening statement, the evidence part, then the closing part. So now we have the closing part. The closing argument should be, as the firm suggested, supported by the evidence. It should be supported by the law, legally sustainable. As we said, part of your case analysis is to develop a case theory that is legally sustainable, supported by the law, supported by the evidence. All right? It should be logical, it should be believable. Don't ask people to believe the unbelievable. Of course, a as part of the hearing business, there will be some admissions, there will be some undisputed facts. That's okay. But what really constitutes argument? What is an argument? How does an argument differ from a statement? Now, in the context of legal proceedings, closing arguments, an argument may consist of some or all of the following things. One, drawing conclusions. And the firm gave an example here of the road traffic case. Drawing conclusions from the evidence. We had this, therefore, surely. Conclusions. Bad blood. There was bad blood between Desmond's uncle and Sayyid Muhammad. And that is why Sayyid Muhammad is doing what he's doing to Desmond. Conclusions. Inferences. Inferences based on the evidence. You can infer through deductive reasoning or inductive reasoning. You can make inferences. Now, I've just remembered a useful point. Well, you can go and read up on this. Just when I mentioned inductive reasoning and deductive reasoning, I remember that the old Greek philosophers taught us that the art of persuasion is premised on three pillars: logos, ethos, pathos. You can go and talk to Dr. Google later about those three pillars of persuasion. Logos, ethos, and pathos. Now, inferences. Something else you can argue: circumstantial evidence. Circumstantial evidence. And I am sure all of us know what that is all about from our evidence law class. You know, circumstantial evidence. You may not have direct evidence to suggest or to show that this accused person committed the offense, but the circumstantial evidence available points inescapably to the guilt of the accused person. Analogies, allusions, can use them. Credibility, you can argue credibility. So, in a closing argument, you can argue that this is not a credible witness because, remember, for instance, when we discussed impeachment, if you have done a successful impeachment of a witness, you can then argue in the closing that this witness is not credible. Right? You can argue motive. Motive is another thing you can argue. Motive. Why did the accused person commit this offense? All right? Why? A deal gone sour, a love triangle, business rivalry, greed for profit, all those. You can argue motive. Demeanor of witnesses. I know that's usually for the court to observe, but nothing stops you from arguing demeanor, such as when a witness hesitates or refuses to answer a certain question. You can comment on it and say, well, what does this tell us? Something else in argument is where you refute the opposing sides' positions about things by showing, so refutation. You can do refutation by showing things like errors, you know, on the part of the other side and their witnesses, inconsistencies, you know, inconsistencies, contradictions. It's part of refutation. Implausibilities, showing that something surely is not plausible, it's not logical, it's not reasonable. It really, things don't happen like that. It's implausible, you know. You can also argue, although this must be taken with some caution, moral appeal, but with some caution, because when we say moral appeal, we are not saying that a court of law is a court of morality. No, this is essentially about empathy, you know, empathy, where applicable, you know, empathy, not sympathy, empathy, moral appeal, and finally, application of the law. So, application of the law is also argument. You say the law on this point is as follows. Of course, lawyers are notorious for saying, my Lord, the law on this point is well settled. It is straight law, even when it is not. So, finally, there are certain things that you should not do. The farm mentioned a couple of don'ts, and that's okay, I agree with all of them. Let me underscore, just for emphasis purposes, things to be avoided. 1, statements of personal belief. Statements of personal belief. Whatever you do, whether you are making your submission orally or in writing, you don't want to hear from you things like, Your Honor, I believe that. Nobody is interested in your beliefs. Your Honor, in my opinion, nobody is interested in your opinions. Instead, make a submission. Your Honor, we humbly submit that. It is our humble submission that nobody wants to hear what you believe in, what your opinion is. Your Honor, I think that. We don't want you to tell us what you think. Instead, make a submission. Statements of personal belief to be avoided. Avoid, number 2, referring to things said off the record. So in the course of the hearing, some things may be said off the record. The judge could say, counsel, off the record. Off the record. Now, if something is off the record, it remains off the record. So don't refer to it at all in your submissions. It was off the record, it remains off the record. Number 3, appeals to prejudice or bigotry. Now this is a serious business. Avoid any reference to any sort of prejudice or bigotry. You know? Sexist language. Racist language. Tribal language, including stereotypes. You know? Disability. Religious beliefs, unless relevant to, unless it's a facting issue, right? Of course, all these things that we are saying we avoid, you can only speak about them if they are a fact in issue. For example, the case is your client is a victim of discrimination on account of gender, disability, race, whatever. If that is what the case is all about, then you can talk about those things. But otherwise, don't. Economic status, unless relevant, don't talk about it. Any appeals to all those sort of aspects of prejudice, bigotry, to be avoided. I hear these days, even the football club that you support is an aspect of prejudice. You know, you can say something, Your Honor, as we saw yesterday, the way Man U are hammered. Now, if the court turns out to be a Man U fan, you lose your case. I assure you, you will lose. Next, avoid misstating the evidence. Avoid misstating the evidence. I know this is controversial, yes, but do not misstate the evidence. Also, related to that, don't refer to excluded evidence. So in the course of the hearing, because of the trial, certain evidence may be excluded by the court because the court has ruled something to be inadmissible, a certain question to be unacceptable for whatever reason because of objections. Now, those things that are excluded, they remain excluded. So in your closing, you can't refer to them. Next, this is controversial. Avoid misstating the law. Lawyers are most notorious for misstating the law. Yet they are lawyers. Anyway, next, avoid, and this is to be avoided at all costs. Avoid appeals to the judge's personal interests. Even if you know them, even if you know them, don't appeal to the judge's personal interests. You cannot say, my Lord, I know you are an avid golfer, and as we say in golfing, no, you cannot. You cannot say that. Even if you know the judge's personal interests, you must leave them out of this business. You must also avoid appeals to sympathy. You know, this is a court of law. Empathy, yes. Sympathy, no. Lastly, avoid making comments with respect to privileged occasions or material or whatever. If the law gives me a right to make an unsworn statement, and I exercise that right, as a prosecutor, you cannot be heard to say something like, Your Honor, you also, the fellow refused to give a sworn statement so that we don't cross-examine him. You can't say that. Because the person exercised a legal right guaranteed by the law. So you can comment about what they said in their unsworn statement, but you cannot, you can't cast aspersions, on a witness's exercise of a right, like giving an unsworn statement or even declining to give any evidence at all. It's my right. You submit on the evidence you presented, but you cannot comment by saying, you see, Your Honor, the fellow refused to testify. It's a criminal case. It is your business to prove the case against the accused person beyond a reasonable doubt. Right? Now, I should, of course, emphasize part of the conclusion. When you are concluding your closing argument, I know we are running out of time. In criminal cases, your last statement, if you are the prosecutor, you conclude by asking for a conviction, and you stop there. It is premature to talk about sentence in a closing argument. Your last plea to the court is a conviction. There will be a time later to talk about sentence. If you are counsel for the defense, you stop at asking for an acquittal. That's it. In civil suits, be specific. Ask the court for what you want for your client. Don't just say, and so, Judge, we are asking you to do justice to my client. Thank you. What do you want? Damages? What kind of damages? How much? You know, in the oral exams, this candidate was asked, what is the difference between special damages and liquidated damages? The candidate has no idea. Then I said to my colleague, that one, not yet. How can you not know first year basics? So, damages, permanent injunction. You want specific performance. You want restitution. You want a share of the property. What share? If you have Mweny's lawyer, don't say, and so Judge, please give my client a fair share of it. Say what you want. You may not get it, but say, I want a half share of the land. Alright? Specifically, say to the court what you want. It's a suit for defamation. We are asking for general damages for defamation. How much? Based on what? You have cited case law to support that kind of award. You want exemplary damages, you want punitive damages, and what have you. Alright? So be specific.